You heard me talk to the nominee for the Third Circuit about how she would interpret the Constitution, and she said that the Constitution should be interpreted according to its meaning as understood by the people in America at the time the Constitution was passed. Do you agree with that?
I do, Senator.
Okay. Let me ask you what I asked her. How do you square that with Brown v. Board of Education?
I would adopt a lot of what she said, actually. I believe the 14th Amendment, as it came in, addressed.
14th Amendment was later.
It was later. It was a reconstruction.
Can you turn your microphone on, please?
Sorry
Thank
about
you.
that. I believe the Brown versus Board of Education is correctly decided.
I do too, but when my friends, and I'm a textualist as well, but when my friends say, well, we have to interpret the Constitution in accordance with the way the average American viewed the Constitution at the time. I say, okay, that seems fair to me. Do you think that the average American at that time looked at the Constitution and supported and believed that it provided for racially integrated schools? Do you think that was a majority view at the time?
Senator, all I know is that Brown versus Board of Education is good law, and it was correctly decided.
And why do you think it was correctly decided? I agree with you, but why?
Well,
If you interpret the Constitution by looking at its public meaning at the time.
separate was not, it was inherently unequal, not equal. And
It was what?
I just don't believe that there's any appetite in this country for any type of de jure type of segregation. I believe
At the
that
time
case.
the Constitution was passed?
I'm talking about right now. I believe that it's good
No, but
law,
I mean,
Senator.
okay.
Senator John Kennedy has made a name for himself as one of the sharpest interrogators in Senate hearings. He mixes a folksy style with razor-edged legal questions that leave nominees stumbling. In this exchange, Kennedy pressed judicial nominees on some of the bedrock principles of constitutional law, the rational basis test, the difference between notice pleading and fact pleading, and the ever-controversial theory of originalism when stacked against Brown v. Board of Education. What played out in this hearing wasn't just another dry law school lecture. It exposed how shaky some nominees can be when asked to explain the very foundations of American law. And more importantly, it raised a hard question. Can judges really cling to rigid doctrines like originalism without running into contradictions when faced with landmark rulings that reshaped American life?
Senator Kennedy.
Thank you, Madam Chair, and congratulations, gentlemen. I thought I would just start down here and then move this way, if that's okay. Judge, what is the rational basis test?
Senator, I believe the rational basis test is going to be one of your least stringent tests, and whether a law has a rational basis for the outcome intended or the governmental interest that you're trying to obtain.
Okay. What if the legislature or the Congress, as the case may be, doesn't list a reason? What if they just pass the statute?
Senator, I would submit that probably happens many times, and I think it's the role of the court when determining such matters as a definition. I think it's the role of the court to determine whether the usage of that statute, using its wording in plain meaning, whether the usage of that statute is going to reach the governmental interest that you hope is obvious, but sometimes you have to determine.
So you just create the basis, the reason for the statute?
I don't think that you create it, Senator, but I don't think that most statutes, to be honest, I don't think that they tell you what they are trying to accomplish so much as they say, this is the law. For example, possession of a narcotic. It's going to say it's illegal to possess this. We determine if there's a rational basis that forwards the ends of the governmental interest.
Well, how do you determine if there's a rational basis? Do you look at the statute or do you look behind the statute?
Well, I think that you always look at the statute. Now, I think you also look at any other precedent or case law that has interpreted the statute. However, you look to the language of the statute to determine what it does and what effect that might have.
Okay. Counselor, let's suppose that the legislature passes a statute that says if you have a college degree or a more advanced degree, you don't have to take a driver's license test. And let's suppose that assume for a second that the federal court has jurisdiction over a challenge to the constitutionality of that test, of that statute, rather. What test are you going to apply, Counselor?
Senator, that would be a classification that doesn't turn on any sort of protected characteristic, and so it would be a rational basis test that would apply in that instance.
You don't see any suspect classification?
No, Senator.
You don't see any fundamental right?
No, Senator.
Okay, what if the legislature didn't provide, so you would use the rational basis test?
I would, Senator.
And you would uphold that statute?
I think there could be some rational basis that a court could conceive of to justify that statute, and rational basis is not.
So you would invent the rational basis, the reason for the statute?
That's generally how the test has been applied by the Supreme Court and by lower courts, and as a district court judge, I would be bound by that Supreme Court precedent.
Okay. Judge, tell me the difference, sir, between notice pleading and fact pleading.
Notice pleading, of course, goes to your due process issues under the 14th Amendment.
But what's the difference between notice pleading and fact pleading? We use two systems
Yes,
in
sir.
America, as you know.
Yes, sir. Notice pleading is based on, of course, that goes into your jurisdiction, your personal jurisdiction, and then the fact pleading, of course, goes into your subject matter jurisdiction.
What system does the federal judiciary use, notice or fact?
No, fact.
Okay. Judge, I'm about out of time. Can I have 30 more seconds, Madam Chair? You heard me talk to the nominee for the Third Circuit about how she would interpret the Constitution, and she said that the Constitution should be interpreted according to its meaning as understood by the people in America at the time the Constitution was passed. Do you agree with that?
I do, Senator.
Okay. Let me ask you what I asked her. How do you square that with Brown v. Board of Education?
I would adopt a lot of what she said, actually. I believe the 14th Amendment, as it came in, addressed.
14th Amendment was later.
It was later. It was a reconstruction.
Can you turn your microphone on, please?
Sorry
Thank
about
you.
that. I believe the Brown versus Board of Education is correctly decided.
I do too, but when my friends, and I'm a textualist as well, but when my friends say, well, we have to interpret the Constitution in accordance with the way the average American viewed the Constitution at the time. I say, okay, that seems fair to me. Do you think that the average American at that time looked at the Constitution and supported and believed that it provided for racially integrated schools? Do you think that was a majority view at the time?
Senator, all I know is that Brown versus Board of Education is good law, and it was correctly decided.
And why do you think it was correctly decided? I agree with you, but why?
Well,
If you interpret the Constitution by looking at its public meaning at the time.
Separate was not, it was inherently unequal, not equal. And
It was what?
I just don't believe that there's any appetite in this country for any type of de jure type of segregation. I believe
At the
that
time
is-
the Constitution was passed?
I'm talking about right now. I believe that it's good
No, but
law,
I mean,
Senator.
okay. I've gone way, way over. I'm sorry, Counselor, I didn't get to you.
No problem, Senator.
Senator John Kennedy has developed a reputation for being one of the most effective interrogators on the Judiciary Committee, and this hearing only cemented that image. What unfolded during his questioning was not a simple law school lecture, but a real stress test for judicial nominees, one that peeled back the polished resumes and the practiced talking points to reveal cracks in legal reasoning, shaky understanding, and the contradictions embedded in the conservative legal philosophy of originalism. Kennedy's approach is deceptively simple. He does not begin with obscure case citations or long speeches. He begins with the basics. He knows that if a nominee cannot handle the foundations of constitutional law, then their credibility as a lifetime judge immediately comes into question. This hearing revealed precisely that. The first exchange began with what should have been a softball, the rational basis test. In constitutional law, scrutiny comes in 3 levels: strict scrutiny for suspect classifications like race or for fundamental rights, intermediate scrutiny for quasi-suspect classes like gender, and rational basis for everything else. Rational basis review is supposed to ask whether a law is rationally related to a legitimate government interest. It is the lowest bar. Laws rarely fail it. In fact, law professors often joke that rational basis review is no review at all. It is a rubber stamp. So when Kennedy asked the nominee to explain it, the expectation was clear, a crisp, straightforward answer. The nominee began in that direction, describing rational basis as the least stringent test. But Kennedy, with his instinct for exposing weak spots, followed up with the real problem. What happens when the legislature does not actually provide a reason for the law? This is not a trick question. It happens all the time. Laws often come with no explicit rationale. Legislatures do not always write findings or justifications. Courts are left to guess. The nominee hesitated, then admitted that yes, judges often determine the governmental interest themselves. Kennedy pounced. So you just create the basis? You invent the reason? The nominee resisted that framing, claiming courts merely apply precedent, not invent rationales. But the reality was laid bare. The rational basis test is not really about measuring legislative intent. It is about courts being willing to dream up any conceivable justification. Kennedy, by forcing that admission, highlighted just how flimsy and deferential the doctrine is. It allows laws that are irrational, discriminatory, or plainly unjust to survive as long as a judge can conjure up a hypothetical reason. To drive the point home, Kennedy deployed one of his classic hypotheticals. Suppose, he said, the legislature passed a law stating that if you have a college degree or an advanced degree, you do not need to take a driver's license test. Everyone else does. It is nonsensical. Education level has nothing to do with driving skill. Yet when Kennedy asked how a court would evaluate it, the nominee dutifully answered, rational basis review. No suspect classification, no fundamental right, so the lowest test applies. Kennedy pressed further. Would you uphold it? The nominee admitted that under current doctrine, yes, a court could conceive of a rationale. Perhaps the legislature believed college graduates were more literate, making them easier to regulate. The reasoning is absurd, but under rational basis review, absurdity often passes. Kennedy's point was devastating. The doctrine lets judges uphold arbitrary laws by manufacturing rationales out of thin air. Far from protecting constitutional liberty, it gives cover to government overreach. Having exposed the weakness of rational basis review, Kennedy pivoted to another foundational topic: pleading standards. He asked the nominee to explain the difference between notice pleading and fact pleading. For anyone with even a first-year law education, the difference is basic. Notice pleading, which is used in federal courts under Rule 8, requires only a short and plain statement of the claim showing entitlement to relief. It is a low bar, designed to ensure cases are decided on their merits rather than thrown out on technicalities. Fact pleading, by contrast, requires detailed factual allegations for each element of a claim. It is stricter, historically used in some state courts. The federal system has long rejected it in favor of notice pleading. This is black-letter law. But the nominee stumbled badly. Instead of clearly distinguishing the two, they began talking about jurisdiction, confusing notice pleading with due process concepts and fact pleading with subject matter jurisdiction. It was incoherent. Kennedy patiently repeated the question. The nominee dug in deeper, ultimately claiming that federal courts use fact pleading. That was flatly wrong. Every federal judge in the country operates under notice pleading. For a judicial nominee to miss such a basic point was stunning. Kennedy did not need to belabor the mistake. The nominee's credibility collapsed under the weight of their own confusion. It was a revealing moment. Not every polished nominee is truly prepared to handle the demands of the bench. Having demonstrated cracks in both doctrinal knowledge and practical competence, Kennedy moved to the most politically explosive question: how to reconcile originalism with Brown v. Board of Education. This was where the stakes rose beyond courtroom procedure and into the heart of America's constitutional identity. Kennedy referenced another nominee who had claimed that the Constitution must always be interpreted according to its meaning as understood by the public at the time it was adopted. This is the essence of originalism, the judicial philosophy that dominates conservative legal circles. The current nominee agreed with the principle. That set up Kennedy's trap. If we interpret the Constitution strictly by original public meaning, what do we do with Brown v. Board, the 1954 decision that declared racially segregated schools unconstitutional? Kennedy pointed out the obvious. At the time the Constitution was ratified, and even at the time of the 14th Amendment, most Americans did not believe the Constitution required integrated schools. Segregation was widely accepted. So if original public meaning controls, segregation would have been upheld. How, Kennedy asked, do you square that with Brown? The nominee fumbled. They insisted Brown was correctly decided. They called it settled law. They praised its outcome, but they could not explain why, under an originalist framework, it was right. Kennedy pressed, do you really believe the average American at the time of ratification thought the Constitution prohibited segregated schools? Of course not. So where does Brown come from? The nominee had no answer. They circled back to platitudes. Brown is good law, they repeated. But the logic did not hold, and that was Kennedy's point. Originalism cannot explain Brown. It cannot justify the most celebrated civil rights decision of the 20th century. If original public meaning is the guiding star, then Plessy v. Ferguson, the case upholding segregation, should still be the law of the land. The fact that even originalists celebrate Brown reveals the hollowness of their philosophy. When confronted with moral progress, they abandon originalism or ignore its implications. Kennedy forced that contradiction into the open. This matters because the conservative legal movement has spent decades elevating originalism as a supposedly neutral, principled method of judging. But when tested against America's history of racial injustice, it fails. It fails because the original public meaning of constitutional text was often exclusionary, rooted in the prejudices of the time. To insist on freezing constitutional meaning in that era is to freeze inequality into law. Kennedy's questioning highlighted the stakes. If originalism cannot justify Brown, then it cannot be the sole philosophy guiding constitutional interpretation. Taken together, Kennedy's exchanges painted a troubling picture. Rational basis review allows courts to uphold nonsense laws by inventing justifications. A nominee confused about pleading standards raises questions about basic competence. And originalism, when confronted with Brown, collapses under its own contradictions. Kennedy exposed all of it in a matter of minutes. That is the power of asking simple, direct questions. They strip away polish and expose reality. The broader lesson from this hearing is not just about these particular nominees. It is about the kind of judiciary America is building. If nominees cannot explain the basics of law, how will they handle the complexities of real cases? If they cling to rigid doctrines without confronting their contradictions, how will they administer justice in a changing society? And if courts continue to apply deferential standards like rational basis review, how much protection do ordinary citizens really have against arbitrary government power? Kennedy's questioning reminded us that judicial philosophy is not academic. It affects real lives. When courts uphold discriminatory laws under rational basis, communities suffer. When judges misunderstand pleading standards, litigants lose their chance at justice. And when courts embrace originalism without reckoning with its failures, fundamental rights are put at risk. The hearing made those stakes visible. In the end, what Kennedy exposed was not just shaky answers, but a deeper vulnerability in the conservative legal project. Rational basis review shows how courts enable overreach. Originalism shows how doctrine collapses when confronted with progress. And the nominee's own stumbles showed how fragile the facade of competence can be. These are not minor flaws. They are warnings. Warnings about the limits of doctrine, the importance of competence, and the danger of entrusting lifetime power to nominees who cannot withstand even Kennedy's bluntest questions. What Senator Kennedy exposed in this hearing wasn't just shaky answers. It was a deeper problem with how we select and evaluate judges. Do they know the fundamentals? Do they understand the consequences of rigid theories? And most importantly, do they have the courage to admit when the law must evolve to meet the demands of justice? The rational basis test, pleading standards, and the contradictions of originalism may sound abstract, but they shape how real people experience the Constitution every day. Kennedy's blunt questioning reminded us that beneath the legal jargon are real stakes, rights, equality, and the integrity of our democracy. And if nominees can't handle Kennedy's questions, how can we trust them to handle the weight of the bench?